my channel. Please like, comment, and subscribe. How's the Insurance Act lawyer? How's a maritime lawyer? What is the Jones Act? Also known as the Maritime Act of 1920, the Jones Act covers a number of regulations regarding trading via vessels between the United States, its territories, and other countries. However, this federal maritime law also regulates the relationship between the employer and crew aboard these vessels. Before the Jones Act, maritime workers were limited in the operate options to recover damage for injuries or fatalities aboard ship. As part of the Jones Act, an employer may be found responsible for any injury or fatality arising in part of whole from the negligence of any in it against contractors, officers, or employers. The Jones Act also covers injuries sustained as a result of unseaworthy vessel, defective equipment, or mechanical failure. What does the Jones Act cover? The Jones Act covers any injury or fatality sustained by an employer as the result of employer negligence. In addition to injuries sustained on the job, the Jones Act also covers injuries sustained while living aboard a vessel, when embarking or disembarking a vessel, or during any other normal activity. The Jones Act clearly defines what qualifies as a vessel. Employers can also be found negligent and responsible for injuries sustained aboard the vessel if the employer requires excessive overtime which leads to negligence, the employer fails to maintain safety equipment, the employer fails to inspect and maintain all mechanical components of the vessel and the vessel is deemed unseaworthiness, the employer fails to select a competent captain, engineer, and or other crewmen. The employer fails to avoid heavy weather including storms, choppy seas, and etc. The employer fails to provide enough fuel and or other sources of energy for the vessel. The employer fails to properly supervise workers. The employer fails to provide adequate medical attention when working or hurt. The employer fails to prevent assault or attack from the other crewmen. The employer fails to provide rescue for workers who are thrown from the vessel. If you are not unsure of whether this situation applies, a hostile Jones Act lawyer can help. What does the Jones Act cover? Those who qualify as the Jones Act seamen include the crew of a vessel or ship, as well as workers on the barge, cargo ship, semi-closed ship, or cruise ship, maritime workers on a construction barge, dredge, drill ship, fishing vessel, and floating crane also qualify. There are numerous maritime jobs that allow seamen to qualify for a coverage under the Jones Act, from deckhands to commercial divers. Merchant mariners may also be entitled to Jones Act benefits. Seamen who can prove their injuries were due to the negligence, either in whole or part of the offshore employer can file claims for. Medical expenses including doctor and hospital visits, imaging surgeries, physical therapy, medication, etc. Pain and suffering including mental anguish, cost to collect benefits, loss of wages, and benefit loss of motility who qualifies as a Jones Act seaman. The Jones Act regulates the relationship between the employer and crew aboard the vessel, supporting workers' injury on the job. Before the Jones Act, maritime workers have had a limited number of options for recovering damages after an injury or fatality aboard a vessel. Determining who qualifies as a Jones Act seaman can help maritime workers and their families with financial recovery. What qualifies an offshore workers as a Jones Act seaman? To qualify for coverage under the Jones Act, a person must also qualify as a seaman for purpose. In general, a seaman for purpose is a person who spends a significant amount of his or her time working as a crew member or captain on a vessel. The ship or boat must also be in navigation, which is moving or movable. Establishing these two requirements, a vessel is in navigation and the amount of this working, will help to determine an offshore worker's qualification as a seaman and thus his or her coverage under the Jones Act. A vessel is said to be in navigation if it is floating in operation, capable of moving, and in doing so in navigable waters. There is no requirement that the vessel must be moving, only that it can be capable of moving. This is an important distinction as it opens the Jones Act to workers at shipyard and docks when vessels remain in the water, but are still fully capable of moving. Navigation, when used as a legal term, means the vessel is capable of being used for interstate or foreign commerce, ocean, space, and gulf system, or qualify along with the waters that are connected directly to them. Even some landlocked lakes can be classified as navigable waters if they extend into another state or a rare connection through a river contributed to a working vessel. The second requirement for qualifying a Jones Act seaman is the maritime employer's contribution to the work of the vessel. It requires that at least 30% of the employee's total work time must be spent on a vessel or aboard a fleet of vessels. If the work line exceeds the 30% mark on a vessel in navigation, the employer is a seaman for purpose. Qualifies as a Jones Act seaman. The House and Jones Act seaman injury lawyers at Richard J. Placia and Associate can review your work records and help determine if you qualify for the match recovery under the Jones Act. What is considered a vessel under the Jones Act? The Jones Act covers any injury or fatality sustained by an officer employer as the result of employer negligence, enacted in 1920 as the Merchant Marine Act. This federal legislation helps seamen recover damages for items including medical bills, lodged wages, and mental anguish. Only maritime employees working on a vessel qualify for coverage. What is a vessel under the Jones Act? Vessel requirement. The Jones Act requires the vessel to be in navigation. The navigation condition can be made using these 4 points. Afloat, in operation, capable of moving, on navigable waters. The words capable of moving are important as the verbiage allows for maritime employees working on ships in wet docks and shipyards to qualify under the vessel requirement. Dry dock ships are not capable of moving and would not qualify. Navigable waters are defined as any water system used for commerce. This includes oceans, bays, gulfs, and the waters that connected them, like rivers. Any water capable of use for navigation will qualify. The Jones Act helps to protect the workers on U.S. waters that are vital to economy. The Jones Act covers over 39,000 commercial vessels that transport approximately 1 billion tons of cargo. Important benefit of the Jones Act. The House and Jones Act negligence attorneys at Richard J. Placia and Associates have years of experience representing maritime workers who qualify under the Jones Act and recovering damages. Workers who can prove that their injuries were caused either in whole or part by the negligence of an officer employer can file claims for medical expenses, including doctor and hospital visits, imaging surgeries, physical therapy, medications, and long-term rehabilitation. Pain and suffering, including mental anguish, cost to collect benefits, loss of wages and benefits, loss of motility. House and Jones Act negligence lawyer. If negligence by your maritime employer has injured you, contact the maritime attorneys at Richard J. Placia and Associates for a complimentary review of the facts surrounding your case. Your injury can be caused by many different acts of negligence. A few of these include unmaintained equipment, the failure to provide safety training, failure to maintain signage, poorly training crews, and seaworthiness vessel claims in Texas. House and Jones Act negligence. The owners and operators of maritime vessels or the seamen that work on these vessels the duty of maintaining it in seaworthy condition. All parts of the vessel that are used must stay in suitable working condition, be maintained properly, and be in safe working order. When they fail in this, an injury occurs, and seaworthiness vessel claim in Texas may be possible. Seamen are protected against unseaworthiness vessel under the Jones Act and General Maritime Law. Poorly maintained ships can be riddled with danger for the workers who are employed on them. If you have been injured as a result of an unseaworthy vessel, House and Jones Act negligence attorney at Richard J. Placia and Associates can help hold the owner and operator of your vessel accountable for your injuries. What is the doctrine of unseaworthiness? The doctrine of unseaworthiness holds owner and or ship operator responsible for providing a seaworthiness vessel. Generally, this means that anything that is part of the ship or connected with the vessel must be in safe working condition. The doctrine also requires that an adequate crewmanship. The doctrine makes the owner liable for any injuries that stem from poorly maintained equipment or a badly trained crew. What makes a ship unseaworthy? The term unseaworthy is an all-encompassing term that relates to a ship's condition of maintenance. The following categories are common examples of unseaworthiness vessel claims in Texas. Worn-out equipment and fixtures that need replacement to be in proper working condition. Missing equipment and fixtures, example no veil protection or other safety equipment on the ship. Failing or slipping hazard left undressed. This could be an oil slick that isn't clean or a rope left in a place where other seamen walk. Lack of safe access between the ship and the shore, like an unsafe gangway, missing warning sign or unreadable post sign. What makes a crew inadequate? The seaworthiness doctrine is unique because it also addresses the crew working on the ship. Even inadequate crew causes or is related to the cause of your injury, you could be compensated under a theory of unseaworthiness. Conditions related to the crew that make a vessel unseaworthiness include breaking safety rules, lack of proper training and certification, working excessive hours, poor supervision, insufficient crew to perform its important tasks, lack of safety procedures, absence of safety and training drills. Thanks for watching. Don't forget to like, comment, and subscribe.